This exchange between Senator Dick Durbin and Senator John Cornyn captures a deeper constitutional and moral debate about federal power, state sovereignty, and political theater in America's immigration and law enforcement battles. Senator Durbin's central argument is that President Trump's decision to deploy National Guard troops to Illinois without a clear legal foundation is not a matter of security but of politics. He sees it as an overreach, one that mirrors past instances when the federal government's use of force raised constitutional alarms.
Thanks, Mr. Chairman. At our last meeting last week, two of my Republican colleagues defended President Trump's unlawful attempt to deploy the Texas National Guard to my home state of Illinois. I want to take a moment to respond. One colleague compared Trump's actions to President Eisenhower, deploying the 101st Airborne Division to desegregate Central High School in Little Rock, Arkansas in 1957. Most of my colleagues here are too young to remember the civil rights movement, but there is no comparison between Arkansas's massive resistance to desegregation and Illinois' peaceful and lawful opposition to this administration's immigration policy. Arkansas Governor Orville Faubus called up the Arkansas National Guard to block black students from entering Little Rock Central High School in defiance of the Supreme Court decision in Brown versus Board of Education. The 101st Airborne, dispatched by President Eisenhower, was deployed to ensure these students, the Little Rock Nine, as they were known, could safely attend school. They weren't tear-gassing pastors, journalists, and police officers, as the federal agents are now doing in Broadview, Illinois, a suburb of Chicago. They didn't rappel from Black Hawk helicopters in the middle of the night to swarm an apartment building, breaking down doors, rousting families out of bed, zip-tying and detaining U.S. citizens, including children, as federal agents did in Chicago's South Shore neighborhood 2 weeks ago. That is a fact. And then the senior senator from Texas compared my opposition to Texas National Guard being deployed to Illinois, to southern states defending the institution of slavery. He said, and I quote, attempting to resurrect a long-rejected idea associated with slavery in the early days of the United States, that the state and local officials can nullify federal law. The senior senator from Texas is a good lawyer, and he's well aware of how limited that comparison is. I'm not arguing that states can override federal law. I'm arguing that President Trump is violating federal law. Don't take my word for it. Judge Karen Immergut, a conservative Republican appointed to the federal bench by President Trump, blocked the deployment of the National Guard in Portland, Oregon. Listen to what she said, and I quote, and let me remind you again, a Trump appointee, quote, this country has long-standing and foundational tradition of resistance to government overreach, especially in the form of military intrusion into civil affairs. This is a nation of constitutional law, not martial law. That's what the judge said. Or listen to Republican Oklahoma Governor Kevin Stitt, another conservative. And he said, quote, Oklahomans would lose their mind if Governor Pritzker, in Illinois sent troops down to Oklahoma during the Biden administration. I'm sure they would have. And I'm sure at a guarded moment in a spy secret ballot, every member of this committee would agree. Here's the reality. The president's actions are about politics, not public safety. For the past 2 decades, the murder rate in red states has exceeded the murder rate in blue states. But the president is focused on Chicago, where violent crime is down dramatically. We should build on that success and work together, not undermine it. As I told the Attorney General, it is my job to ask fundamental questions about whether the federal government is following the law and Constitution. But she refused to tell me when I asked what was the legal basis for deploying the National Guard in Illinois. Instead, she launched irrelevant and false personal attacks. In more than 2 decades on this committee, I've never encountered a witness from any administration, Democrat or Republican, respond to legitimate oversight questions with personal attacks on the senators on this committee. That testimony by the Attorney General demonstrated the disdain she has for this committee and the constitutional responsibility we share to conduct oversight, regardless of the party in charge in the White House or Congress. We also need to hear from Department of Homeland Security Secretary Noem. She made time to go to Chicago for a glossy promo video, but she refuses to meet with me and Senator Duckworth. She won't respond to our oversight request and denies us access to detention facilities in the state we represent. We were there last Friday. There were demonstrators there. In the course of the day, 4 were arrested and detained. It was a quiet day. People were exercising their constitutional rights in a nonviolent fashion, as they should. When I was chair of this committee, I held a DHS oversight hearing with Secretary Mayorkas during the first year of the Biden administration. He faced tough questions from both sides of the aisle. You probably remember it. Unlike the current Attorney General, he didn't insult this committee with his responses. Mr. Chairman, we sent you a letter in June asking when Secretary Noem would appear before the committee. I hope, again, for the record, you'll make it clear that that's going to happen soon.
Senator Durbin, would you yield for a question?
Yes, of course.
Thank you.
We don't
You
have
said
a
that the
schedule yet,
president
but
violated federal law, and what federal law did he violate by sending National Guard troops to Chicago?
Well, the question is, what federal law did he follow to send those troops, and he couldn't produce it in the court in Oregon?
I'm sorry, I didn't understand that.
It's been contested as to whether he has the authority to send in the National Guard. In the court in Oregon, I just quoted the judge. There is no basis for his doing
Well,
so.
you didn't say what federal law, what law he violated. Is it illegal for him to send federal officials there to enforce
There are legal
federal law?
authority. There are legal authorities for him to do it, and he hasn't been able to establish in court successfully that he's followed them.
Well, I wish if you're
fact,
going to
he keeps
accuse the president of violating federal law, that you could actually tell us what law you
Well,
think he
I asked
violated.
the senator from Texas, why does he keep bringing up the Insurrection Act?
Well, he hasn't asserted any right under the Insurrection
For good
Act.
reason. There is no
But this
basis.
is, to answer your point about the border, in the absence of federal law enforcement along the border, or actually when the open border policies of the Biden administration were in place, Border Patrol was overwhelmed, so Governor Abbott sent National Guard and Department of Public Safety to the border to back up the border
Of his own
patrol,
state?
not to enforce the law,
State,
but to
Texas?
supplement their efforts so they would free them up so they could deal with the challenges that they had as a result of being overwhelmed.
Were these border areas in your state of Texas?
Say that again?
The border areas that the governor sent the National Guard to, were they in Texas?
Yeah.
Well, that's a totally different story than we're facing in Illinois.
Durbin carefully contrasts the situation in Illinois with the historic deployment of troops by President Eisenhower during the 1957 Little Rock desegregation crisis. Eisenhower's decision then was to enforce constitutional rights against a state defying the Supreme Court's ruling in Brown v. Board of Education. Trump's deployment, Durbin argues, was the opposite, a political maneuver to impose federal force on a state lawfully exercising its own authority. Durbin also points to the hypocrisy and selective outrage in how some Republicans frame law and order. He cites Judge Karen Imrat, a Trump-appointed conservative who ruled that the federal government's intrusion into civil matters through military force violated constitutional limits. Her reminder that this is a nation of constitutional law, not martial law, serves as the backbone of Durbin's case that no president can use troops as political tools. Cornyn, in response, presses Durbin to specify which law was violated. His questioning tries to force Durbin from the moral argument into a legal technicality. But Durbin reframes the issue. He argues it's not about a single statute being broken, but about a pattern of executive abuse and disregard for legal precedent. He invokes how courts have already ruled against similar actions, like in Oregon, where federal intervention under the pretext of public safety was found unlawful. Cornyn's counter-argument is steeped in federal supremacy and national security logic. He insists the president has clear authority under Title 32 to deploy National Guard troops to protect federal facilities and enforce immigration laws. His framing positions Democrats, particularly Illinois Governor J.B. Pritzker, as part of a resistance movement obstructing federal law enforcement. Cornyn ties it back to a historical narrative, accusing Democrats of again being on the wrong side of federal authority, referencing Reconstruction and desegregation eras. This rhetorical pivot reveals a larger clash. Both senators are invoking history, but for opposite purposes. Durbin draws from it to warn against authoritarian overreach, while Cornyn uses it to justify federal assertion over defiant states. Each claims the moral high ground, Durbin through constitutional restraint, Cornyn through national unity under federal law. But beneath the sparring lies a sobering truth. The use of military power inside the United States is one of the most sensitive issues in American democracy. The Insurrection Act, Title 32, and the Posse Comitatus Act all draw delicate boundaries between civilian law enforcement and military authority. When those lines blur, history shows the consequences are grave, from Kent State to Portland to Chicago today. This debate also underscores a recurring theme in American politics. Federal authority expands most in times of fear, often justified by security concerns. Durbin's warning echoes this. When leaders use law enforcement and the military as political props, the Constitution suffers. Cornyn's argument, though legalistic, shows how easily executive power can be rationalized as protection. For viewers, the takeaway is this: the debate over federal versus state authority isn't just about immigration or politics, it's about the preservation of democratic norms. When one side normalizes force to settle political disputes, it sets a precedent that erodes civil liberties, oversight, and local autonomy. And that's why this hearing matters. It's not merely a spat over the National Guard. It's a reflection of how America grapples with power, law, and principle in an era when all three are increasingly blurred. If you found this breakdown helpful, stay tuned for more in-depth analyses of political hearings and real-world power struggles. Let's keep cutting through the noise and getting to the truth together.